Hi, my name is Randy Hicks, and I've been a California adoption lawyer for 38 years. And today we're going to talk about step-parent adoption. I'm going to talk about the laws and the procedures, the timetable, the cost, really everything that you need to know. And I'm even going to tell you one particular fact that the average family law lawyer doesn't know, that I know as an adoption specialist, that's going to help you make sure your adoption goes quickly and smoothly. I'm even going to talk about how to choose an adoption lawyer. Now I'm going to go pretty quick. I know your time is valuable, so I'm not going to waste any time. I recommend you don't skip or you might miss something important. Are you ready? Let's get started. All right, let's go quickly through some really important but basic facts. First, what exactly is a step-parent adoption? Well, a step-parent adoption is adopting the child of your spouse or a registered domestic partner. Where do you file your step-parent adoption petition? Well, that's typically done in the county where the adopting parent lives. You have to be a California resident. Do you have to be a resident for a certain period of time? No. The family code doesn't set any particular minimum amount of time as long as you are officially a resident. Is there a minimum time period you have to be married before you file your petition? The answer is no. The family law code sets no particular minimum amount. So in theory, you could be married one day and file your petition for adoption. But you are going to hear some people tell you that there is a one-year requirement. And where you get that technically incorrect answer is that some of the entities which investigate and approve step-parent adoption, and I'm going to talk about that more in a minute, sometimes they have the recommendation that you be married for at least a year. But that's generally a recommendation, not a requirement. How long does it typically take to complete a step-parent adoption? I would say with my office, they're faster than they are with most lawyers, and the time frame is usually about 4 to 8 months, most falling around the middle. And if you're wondering why is there such a wide range in that, it really depends mainly on the county in which you live. Because some counties get us to court very quickly. For example, in Los Angeles County, we can quite often get into court within about 5 weeks of requesting our hearing date. But in other counties, let's say Orange County, we might wait, at present, it's about 5 months to get our hearing date. So that's the biggest single factor that controls it, other than the main issue, which is, do we have the consent of the absent parent? That's a very important legal issue I'm going to talk about in detail in a minute. That's another factor that's going to determine how long it takes to complete your adoption. Hey, before I go any further, I should probably give you my experience and qualifications because you want to make sure you're getting information from someone you can rely upon. So as I mentioned before, I've been a lawyer for 38 years, and I've limited my practice exclusively to adoption that entire time, one of just a few attorneys in the state that does that. I love to educate people about adoption, so I've written quite a few adoption books, both on adoption generally and specifically on step-parent adoption. And they've been featured on several national news programs as well as national talk shows. I've always been active regarding new adoption legislation. I've drafted a few adoption laws myself, and I've been an advisor to the California legislature regarding new adoption laws. If you want to check my ratings, you can go to avo.com, which is a site which lets people review their lawyers. I have over 180 5-star reviews on Avo, I think more than any other adoption attorney in the state. And I also have a 5-star average rating on Google and Yelp. The main attorney rating service called Martindale-Hubbell has given me the highest possible rating. All right, enough about me, back to the legal stuff. So let's go through the procedural basics in terms of what you're going to be doing. Some of this is going to sound a bit intimidating and complicated, but hey, that's why we lawyers exist. But I want you to know exactly what's going on. So the first thing you'll do is file your petition for adoption. That's a document basically telling the court who everybody is and showing that you meet the legal requirements to do a step-parent adoption. Are there a lot of documents required in doing a step-parent adoption? Well, yes. The petition for adoption is just one of many. There's also the adoption agreement, the spousal consent, There's what are called ICWA forms. That's actually a nickname. The technical term is Indian Child Welfare Act forms. Basically, those are forms that determine if a child has any American Indian heritage, Native American heritage, it might trigger a federal and state law called the Indian Child Welfare Act, which can change these basic California laws that I'm talking about. There's also the order of adoption, which is what is used to grant the adoption. That's prepared by the lawyer, not the judge, as you might think. There's a court report to adoption, the VS-44 form that helps generate the new birth certificate, which we'll talk about later. And there's all kinds of ancillary forms that depend upon the county in which you live. There might be a certificate of assignment, notice of related case, various cover sheets, certificate of lodging, and so on. And yes, this is complicated, but that's why you're going to choose a good lawyer. After you filed the petition for adoption, the next significant thing we're doing is the step-parent investigation. You're going to hear it called a home study quite often, but technically there's a difference between a home study and a step-parent investigation. A home study is what's required in a full, complete adoption. If you're adopting a non-relative, a newborn child, but because you're adopting your spouse's child, the court basically gives you a break and figures, well, if you've already been a parent to this child already as a step-parent, and the child's mother or father has approved you by marrying you, they kind of give you the benefit of the doubt. So the cost is much lower. A full home study for a traditional adoption is usually $4,500. But in a step-parent investigation, it's only $700, or in some cases it can be less. I'll talk about that in a second. Now, the reason they call it an investigation and not a home study is, for one thing, they typically don't come to your home like they would in a regular adoption home study. Normally, in a step-parent investigation, you go to the social worker's office and talk with them there. So there is an interview that's required. There's a questionnaire for the adopting parent to complete. The adopting parent has to go through a criminal background investigation, so you will be fingerprinted, and also run through the Child Abuse Registry and the California DMV. Now, you can still be approved to adopt, even if you've got something not perfect in your record. Maybe it's a criminal violation, maybe a DUI, something like that. Again, they don't expect you to be perfect, but what they do expect is that you've learned from whatever mistake that you made. And the child's best interests will be served by you being their parent. In other words, you're a loving parent who's going to meet the child's needs. The second biggest issue after the investigation is getting the consent of the absent parent. Let's say, for example, that you are the adopting father and you're adopting your wife's child. By the way, in about 95% of the cases that I see, the adopting step-parent is the father figure. It's more often for the birth father to be the absent parent than a birth mother. So we need the consent of that absent parent in most cases. Again, that's going to be the birth father. Now, it's not complicated in terms of actually having a consent signed. It's a specific document. It needs to be witnessed by a notary, the social worker, or a court official, typically a judicial officer. But the big issue comes in, what if we can't get the absent parent consent? Either they have disappeared and we can't find them. Maybe we can find them and they just say, I'm not going to consent. I don't want to do it. Even if they've been absent from the child's life and provided no contact, no support for 10 years. Sometimes their refusal seems somewhat unbelievable. But by law, we need the birth father's consent, or we need a court order terminating their parental rights so a consent is not required. Now, talking about the issue of birth father rights is complicated. I'm going to do my best to make it simple. There's two legal categories of birth fathers, what are called presumed fathers and what are called alleged fathers. Presumed fathers have stronger legal rights, meaning we have to go through more to terminate their parental rights, than alleged fathers. So what is a presumed father? There's many ways to be considered a presumed father, but the main ones that we deal with is the birth father is named on the birth certificate, was married to the biological mother, or at some point in the child's life, even for a short period, the child was living with the birth father and was held out by the birth father as his own child. A birth father who's not meeting those designations is in that weaker category called an alleged father. So what do we have to prove if we want to terminate the rights of a presumed father? Well, there's actually several different legal procedures that we can use to do that. I'm going to talk about just the main one, which is covered in Family Code section 7822. And I'll put it on screen. You can pause it and read it if you would like. But a basic summary is that we have to prove that at least 1 year has gone by with no contact or no support between that absent parent and the child. In other words, were they sending money? Were they visiting? Were they sending birthday gifts? Things like that. And we don't have to prove both lack of contact and lack of support. It's just one or the other. Now, it's ideally a stronger case if we can prove both. And the minimum time is at least 1 year. And again, the more years, the better for your case. So there's some good and bad news in this scenario. So the bad news is that if we have to go to court to terminate parental rights, that's a whole additional legal action to the step-parent adoption itself. I mean, it's done under the step-parent petition, but it's a completely separate legal action. So it's going to cost you extra legal fees. It's going to cost you a delay. And I'll talk about fees in a moment. The good news, though, at least in my experience, a significant number of birth fathers might start off saying that they will not agree to the adoption, but quite often we can convince them that it's best for them and best for the child to agree to the adoption. Here's the key thing, at least in my mind and my personal strategy. Number one is I try and treat all birth fathers with civility and respect. I never come on hard as a mean lawyer. That usually accomplishes nothing but increases, adversarial behavior from them. And the other thing is I've learned over 3+ decades of doing this job that the biggest reason that birth fathers say they won't consent to an adoption is not because they really think that the child's life is going to be better if they're involved. Quite often, if they were honest with themselves, they can recognize the step-parent has been a better parent and is doing a better job at meeting the child's needs. So why do they not agree? It's simply male ego. The male pride to say, hey, I'm not, quote, fit to be a father. I'm going to give that job to someone else, is hard for a lot of men to do, especially the type of personality who's the birth father that tends to disappear. So if we can address those issues and convince them that this is the responsible thing, that it's not demeaning them at all without using those particular words. Like I say, this is a bit of a psychological issue. Many of them are going to end up consenting to the adoption. Sometimes there's a little bit of negotiation in terms of things like they might say, well, I'm going to consent, but I want to get, an update, every year on how the child is doing. There's all kinds of additional things that we can do to make them happy within the law. And I'm really happy to share with you the fact that in the vast majority of cases, even when the birth father initially says he's not going to consent, quite often we end up getting that consent. That's not a guarantee, of course. And the other good news is that some birth fathers, even if they won't sign a consent, well, they're not going to actively consent, but neither do they care enough to go to court, face scrutiny and perhaps embarrassment regarding their behavior in front of a judge. So a lot of them simply just don't show up and we win by default. We still have to write our legal briefs and file our petitions and schedule our court hearing and have testimony from the adopting parent and the existing legal parent, usually the mom. But at least that makes it a shorter, simpler trial. So it might be 30 minutes instead of days. What about child support? Well, once the adoption is done and the adopting parent has now taken over full responsibility as that child's parent, any future owed child support is basically over. You can't be collecting that. However, if there's past due support, that is not officially ended by the adoption taking place. So let's say we've now completed your investigation. We've either got the consent to adoption or a court order terminating parental rights. Well, next is the adoption final hearing. And yes, there is an actual hearing in front of a judge. And before you think like, oh my gosh, a legal hearing, I'm going to be nervous. I understand why people are quite often nervous in going to court, because let's face it, we don't go to court for good things typically. But a step-parent final adoption hearing is more like a celebration than a court hearing. Yeah, it's official. There's going to be a judge on the bench and a court reporter and a court clerk and a deputy. I mean, it's all very official. But judges are typically happy. They're smiling. All the court does is verify you understand everything. You want to do the adoption. The final hearing usually takes about 15 minutes. It's sealed from the public, so it's just you and your lawyer. It's completely private. You can bring guests with you. And to show you how happy and casual it is, when the hearing is over, the judge will almost always invite you up on the bench to pose for a picture. So that tells you right there how this is completely different than any other kind of legal proceeding. There's a couple more legal issues that are related to that final hearing that are really beneficial in a step-parent adoption. Number one is you can change your child's legal name as part of the step-parent adoption. Now, normally, if you want to change somebody's name, you've got to go to court, you've got to pay a filing fee, you've got to do what's called newspaper publication announcing the change to the general population, and then go back to court. With a step-parent adoption, you don't have to do any of that. You just include that request in your petition for adoption, and the final adoption order will not only grant the adoption, but also state what the child's new name can be. Now, quite often this might mean if the adopting parent is a man, that the child is taking his last name. But you can also change middle name, you can change first name, you can hyphenate last names. You can pretty much do whatever you want. And related to that is getting a new amended birth certificate. This is one more free bonus as part of doing a step-parent adoption. So your child will automatically receive an amended birth certificate that will seal the existing birth certificate. The new one will list the child's new name if you did a name change. It will list the existing parent. Let's go back to our example of stepdad and his wife, and he's adopting her child. Well, the mom is going to stay the mom. She's still on the birth certificate. Step-parent adoption doesn't remove her as a parent. But now the adopting dad, the stepdad, is now listed as dad with no reference to adoption. All right, so we've covered the whole legal process, but we're not done because I want to talk about one important thing, and that's actually choosing a lawyer, because probably the biggest decision you make in terms of the success of your case, the cost of your case, the speed of your case, is going to be the lawyer that you choose. And I'm going to give you 3 kind of tricky ways to test their knowledge, because knowledge is critical. I mean, if you don't have knowledge as a lawyer, I mean, what do you have that's really important? So I'm going to give you 3 key questions to ask to, in a very clever way, find out what their knowledge regarding step-parent adoption is. But before I do that, I don't want to skip over the fact that I'm a practicing lawyer. I don't just do videos. So you're more than welcome to call my office. And so far I've just been talking about myself, but I do have an of-counsel associate. His name is Alan Hall, and he's a terrific guy. He does all the step-parent adoptions in my office. I do all the adult adoptions and adult step-parent adoptions. That's when the person being adopted is 18 or over, it becomes an adult adoption. So I do those. Alan does the ones of minors. And we've been working together for quite a long time. Alan is a great guy. I joke about the fact that I don't like him very much because he's younger than me, he's better looking than me, and sadly, he's a better litigator than me in trial. So he's a great guy, and he has the same 5-star rating average that I do. There's a lot of things that are unique about us that I think is advantageous to the average client. Most lawyers are going to be charging hourly. In fact, almost all of them do. And lawyers are expensive. I mean, a family law lawyer is going to cost usually at least $400 an hour. And one of the many things I don't like about a lot of lawyers is that they play a game when you hire them, is they'll give you an estimate, but by the time the case is done, the total is always more than they said it was going to be. It's kind of like hiring a contractor, no offense if you're a contractor, but hiring a contractor to remodel your kitchen and they say it's going to be $30,000, Is it ever 30,000 when they're done? No, it's always more because they ran into a problem or something. They've always got a reason. Well, I'm embarrassed in my profession that lawyers kind of play that same game. So we don't. For a regular step-parent adoption that's not contested by the absent parent, it's a flat fee of $2,500. Out of our fee, we pay the filing fee, the new birth certificate fee. We pay the costs that we incur in doing that. That's not separate, which other lawyers would charge you separately for. So it's quite a bit less expensive than many other attorneys will charge you with a lot less experience than we have. And that basically covers everything except your step-parent investigation, that's $700, which you pay directly to them. Now, if your case turns contested, that involves more expenses, like it will with anybody, but we typically offer a flat fee for that as well to make it more affordable. And again, the goal is that you know in advance exactly what your costs are going to be. Another thing that distinguishes us is the retainer agreement. Most lawyers out there, their retainer agreement is something like 10 pages. And I'm talking about little tiny, tiny type. And I don't know if they make it that long because they don't want you to read it, or maybe not understand it, or both, I don't know. But the retainer that Alan and I use is 2 pages. It's very simple, direct. I think it's a terrible way to start off with a client if you give them a 10-page document that they can't even understand. And lastly, we offer free consultations. And a lot of lawyers do that, but the average, quote, free consultation is really nothing more than just a quick, meet and greet with the lawyer. You're not really getting concise information. We're completely different. The consultation's free. It's by Zoom. It's for both the adopting parent and their spouse. And it's extremely detailed. It's geared just to your case, talking about what's going to be involved with the absent parent, gives you a cost estimate, a time estimate, and it goes over the law in more detail than I've done in this video. So I think it's another reason that makes us quite a bit different from other law offices. All right, but let's say that you don't like me and you want to hire someone else besides Alan or me, and that's fine. I'm going to give you some tips right now that are really helpful. So number one, we already talked about the fact that most lawyers out there that aren't adoption specialists like Alan and me, they aren't aware of the fact that a private agency can do your investigation. And that's a big deal. It affects your adoption in so many ways. So if they don't know that, imagine all the other things they don't know. So when you're talking to the lawyer, just innocently ask and say, by the way, what county will we be filing in? And who does the investigation? What are the options there? And if they just say, oh, it's the county office or such and such, and they don't mention the office of a private adoption agency, that tells you right there that lawyer, at least in my opinion, doesn't have the knowledge that you need. And do me a favor, please, don't spread my little secret around. I mean, it shouldn't be a secret. It's in the family law code. But if they don't know it already, let's let them stay ignorant. Number two, when you ask about their fees, ask to actually see their retainer agreement in advance and take a look at it. And if it's one of those lawyers that has a retainer agreement that basically just tilts everything against you as the client and is there to protect the lawyer, and you can't even understand it, that tells you something you need to know. And the last tip I'm going to give you is equally important. When you're hiring an attorney, you obviously want to make sure they're experienced in what you need, which is step-parent adoption, maybe issues like terminating parental rights. These are complicated subjects. Well, if you were to call the lawyer or the receptionist and say, hey, I'm planning a step-parent adoption, a termination of parental rights, how much of your practice is made up of that? They'll probably, they want your business. They're going to say, oh, we do a lot of that. I'd recommend you do something a little bit different. So instead of saying that when you call up, why don't you call up and say, I've got a divorce and a child custody matter. I want somebody experienced. What percentage of your law practice is related to divorce and child custody? Well, if they come back with, 98%, well, that tells you that they've only got 2% that's something else, and maybe only a small part of that is adoption. So it's a good way to find out really where their experience lies. All right, that's it. We've covered a lot of information. I hope this has been helpful for you. I wish you good luck in your step-parent adoption.